questions, and each member has 5 minutes. I'm going to try to ask 2 questions to clarify, I think, 2 important issues. And I'm going to start with you, Ms. Sullivan. And I want to go to this preamble question. Professor Foley noted Article 5 in her presentation to the committee. I looked at Article 5. There is no mention of the word preamble in Article 5. I look, of course, to the preamble to the Constitution, and as memorable as the words may be, I don't believe that they have driven decisions of the court or at any stage. The body of the Constitution does over and over again. I can't recall, maybe I'm just not aware of it. The preamble has been a driving force to establish or to question a person's rights. And, of course, this Constitution in Article 7 spells out exactly what ratification of the Constitution entails. And again, we have an important paragraph which does not include the word preamble at any stage. So my question to you initially is, the argument that this is in a preamble and should be treated differently than other places, you've stated already. But what is your comment on the preamble to the Constitution and the fact that it has not been a driving force?
Preambles can have eloquent power. The preamble to the Constitution is perhaps the greatest preamble ever written. But preambles do not drive the interpretation of Article 5 joint resolutions, and they never did, and no court has ever declared it. And crucially, I want to focus on Dillon versus Gloss, which Senator Graham mentioned earlier, 1921 decision that, of course, did hold that the 18th Amendment was not unconstitutional by virtue of the 7-year expiration date that was baked into it and ratified by the states. That, crucially, was not a preamble. It was the language, the 7-year deadline was an expiration date in the text. Now, why does that matter? It matters because the states vote on the text of the amendment. When they ratify, the states are not ratifying the preamble, they are ratifying the text. So it's one thing to bake the deadline into the constitutional text and have the states vote on it. That might be binding. But a preamble is just advisory. It's your dialogue with the state saying, get this done in 7 years, but maybe we'll revisit it. And if anything, the language of Coleman versus Miller, the 1939 case, is supportive of the view that the Congress does have the power now to say we think the ERA is still vital and we think we should remove the prior deadline. One Congress can't entrench itself into the future by binding a future Congress. One Congress can't prevent the states from exercising their ratification role by setting a binding deadline on the states enforceable by a court. So there's no constitutional decision by the Supreme Court standing in your way. Dillon versus Gloss is inapposite because it was about a deadline in the text and not the preamble, and Coleman versus Miller is supportive of this Congress's role in deciding that the ERA still has a vital role to play today.
So let me go to a second question that was raised by Professor Foley as well as by Senator Graham. Since Congress sent the resolution proposing inclusion of the ERA in the Constitution to the states in March of '72, as we know, 38 states have ratified the amendment. However, 5 of those states have subsequently sought to rescind their ratification. Nebraska, 1973, Tennessee, 74, Idaho, 77, Kentucky, 78, and South Dakota in 79. North Dakota also recently voted to rescind its ratification in 2021. What is the legal significance, Ms. Sullivan, of these state legislatures voting to rescind their ratifications?
It has a state rescission has no force under the text of Article 5, which speaks of ratification and not of rescission. Number 2, when 2 states tried to withdraw or rescind their ratification of the 14th Amendment after it was proposed and adopted, this body rejected that, so there's precedent in this body for rejecting efforts to rescind. And to the extent this body has the power I described before, this body has the power to affirm that those rescissions are ineffective now, just as they were for the 14th Amendment. We wouldn't have had the 14th Amendment today if we'd listened to rescissions.
Thank you very much. Senator Graham.